welcome you to this panel on Africa, digital identity in Africa and the Middle East. I'm Stewart Dresner. I'm Chief Executive of Privacy, Laws and Business, and I'll tell you a bit about that in a moment. I have just 5 minutes for my introduction. Now, this subject we're dealing with, we will distinguish between legal identity and digital identity, two very different concepts. And the questions we'll be thinking of: should digital identity be normalized? A few years ago, the Hong Kong Commission stopped a school using fingerprints for children to take books from the library. And that sort of suggesting that fingerprint should not be a normal means of identification for children from the earliest years. And in Sweden, the Swedish Datainspektionen, the world's first national data protection authority, recently fined a college or university for using facial recognition. And so we'll be thinking about how can data protection authorities promote data protection rights in societies where digital identity is being developed. So it'll just be a few seconds to explain what we do, if we can go forward. Can we move the next slide? I'm trying to move it forward. There we go. There we go. So I've been chosen to chair this session because I started publishing the Privacy Laws and Business Report, as you see, in 1987. Been doing this, our 33rd anniversary next month. And so we've been following. When I started, it was 10 countries. Now it's about 140 countries. We cover everything to do with data protection, law, and business. And these are all available in paper and electronic formats. We indeed are covering this subject of biometric identification in a roundtable next week. We have a conference on Germany in London, and we have our famous annual conference, which is our 33rd annual conference in Cambridge, 29th of June to 1st of July this year. Now, to introduce the panel, I'd like each of you to spend 20 seconds to explain who you are, and then when you come to speak, the audience will know you. So we'll start with Patricia.
Good morning. My name is Patricia Poku. I'm the Data Protection Commission's Executive Director in Ghana, so the regulator of the Ghana Data Protection Authority.
Je suis Marguerite Ouédraogo Bonane. Je suis la présidente de la Commission de l'informatique et des libertés du Burkina Faso et présidente du réseau africain des autorités de protection des données personnelles. Merci.
Thank you. So the first speaker is the head of Data Protection Authority from Ghana, and Marguerite is head of the Data Protection Authority in Burkina Faso and also chair of the African group of data protection authorities. And we move over to, we're doing Africa and Middle East. Tim Land is here, represent Middle East, please.
Thank you, Stuart. Good morning, everyone. My name is Tim Land. I'm the head of the Office of Data Protection in the Abu Dhabi Global Market in the UAE.
United Arab Emirates. Now, Oliver.
Good morning. I am Oliver Butler. I'm
Dr. Oliver Butler.
A research fellow at the Bonane Institute of Human Rights in Oxford and a fellow of Fordham College.
Yeah, the University of Oxford. Not just Oxford, but the University of Oxford. Right, thank you. So we have a very finely balanced group here, authorities and academics. Sorry. Please, Omar.
Yes, I am Omar Seghrouchni. I am the president of the CNDP, which is the DPA, Data Protection Authority of Morocco. I also coordinate a working group inside the African network about identification system and their management.
Yes, thank you. Head of Data Protection Authority in Morocco. And so we have an international regulator as well as national ones. Sophie.
Good morning, bonjour. Sophie Kwasny. I work in Strasbourg for the Council of Europe, heading the Data Protection Unit.
Right, and for everyone who's not from this region, there's a difference between the Council of Europe, which has about 54 members based in Strasbourg, and the European Union, which is a different organisation based in Brussels, with its 28 member states until next week. And then, unfortunately, we will have 27 member states as the United Kingdom is leaving. And I'm deliberately wearing this tie with many flags from many countries to show that I believe in a more international phenomenon. Thank you. I will now hand over to Marguerite, who will talk about some of the trends in Africa.
Bonjour. Avant tout propos, je voudrais remercier les organisateurs de la CPDP 2020 pour l'organisation du présent panel sur l'identifiant numérique. Cette thématique est d'actualité et nous intéresse à plus d'un titre, d'autant plus que dans nos pays, des bases de données existent et qui contiennent des identités aujourd'hui numérisées par nos différentes administrations à plusieurs fins. Également, des ONG et associations étrangères font de la numérisation des données des citoyens africains. Il revient à nous, autorités de protection des données, d'assurer une veille afin de faire respecter les droits, les principes fondamentaux en matière de protection des données personnelles. Aussi, le présent panel nous permettra d'échanger des points de vue et d'enrichir nos connaissances sur l'identité numérique. Je m'en vais vous présenter l'état des lieux de la gestion des identités au Burkina Faso. Donc, il existe des structures qui ont en projet la collecte de données d'identification des personnes. Je cite le ministère du Développement de l'économie numérique et des postes, qui a en projet un identifiant unique électronique des citoyens burkinabés. Et une étude est en attente à leur niveau. Un décret a été pris pour la mise en œuvre de ce projet, mais sans demander l'avis de l'autorité de protection. Également, le ministère de l'administration territoriale et de la décentralisation a un projet d'un système informatisé de gestion de l'état civil appelé SIGEC et un autre projet appelé e-civil. Également, au niveau de ce ministère, un décret a été pris sans faire contribuer la Commission de l'informatique et des libertés, sans déclaration auprès de la CIL. Et également, le ministère de la fonction publique du travail a un projet, ou du moins a recensé biométriquement les agents de la fonction publique. Et là, la Commission de l'informatique a été impliquée. Le projet, le recensement est fonctionnel. Également, la fonction publique burkinabé a mis en place un guichet virtuel de l'administration publique fonctionnelle après avis de la Commission de l'informatique et des libertés. Également, elle a mis en place une ligne pour la gestion de la rémunération du personnel de la fonction publique avec l'avis de l'autorité de protection des données personnelles. L'avant-dernier groupe que je vais citer, c'est le groupe Bolloré, Transport et Logistique au Burkina Faso, qui a mis en place un système de pointage biométrique. Ils prennent 2 empreintes digitales du personnel et après avis de l'autorité de protection. Et enfin, le CAMES, le Conseil africain malgache pour l'enseignement supérieur, a mis en place un système de contrôle d'accès biométrique à ces services avec recensement bien sûr du personnel après déclaration auprès de la Commission de l'informatique et des libertés. Donc j'ai fini et je me prête à vos questions. Merci.
Merci beaucoup. Okay, so in your country, in Burkina Faso, there are several. You're head of your data protection. Let's come a little closer. Sorry. You are head of the Data Protection Authority in Burkina Faso, and you have given us examples of various projects which have been developed without seeking your permission and authority, without your consent. So this is, in some ways, a tension between the administration, the central administration, and your role to protect personal data in your country. So this is the main theme that you have given us. Okay. Thank you. So we now move on to Sophie Kwasny, who is Head of Data Protection for the Council of Europe. And you are based in Strasbourg, and I will move on to your slides. Would you like to control it yourself, Sophie? With the
Yes,
slides?
please.
Yes.
So hello again to everyone. So first of all, a big thank you to the CPDP for yet again organizing a great conference, and it's a great pleasure to be here, even more with the speakers on this panel. So great privilege and honor. I'd like to thank Nanis for putting up the panel for us. Thank you very much. This is a topic that I believe has been neglected by some of us, and I'm very happy that it's brought to light. Some NGOs have tried to put it higher on the agenda. Now DPAs are active, and international organizations also, so I'll be speaking about the work of the Council of Europe. Just a word of introduction, indeed, about the Council of Europe for those who are not of the region. We are based in France. We celebrated last year our 17th, so it's 7-0 anniversary, and our focus is human rights, democracy, and rule of law. So any of the work we are carrying out is to support those three objectives, key objectives. And in the field of data protection, we notably promote a convention, Convention 108. So let me start with this map, and there's actually a mistake. I wanted to correct the number of countries with data protection law. So you see 13, and it shouldn't be 13. It should be 138 countries. As Togo is the latest law that enacted its data protection legislation. This map is a map that is kept up to date by Professor Graham Greenleaf, Australian professor, who's following this very closely. We are aware of the fact that at the moment several countries are working on the development of legislation. So some of the countries that you now see in white are working on this. I apologize for some parts of the color on the map. Let me make the link between those 138 countries that have data protection legislations and our work in Strasbourg on the convention. So Convention 108, as I mentioned, is really our landmark instrument. There is no equivalent. You have no treaty on data protection at UN level. So the UN Special Rapporteur on the right to privacy called for all UN member states to accede to 108, well, actually to 108 plus, which is its modernized form. Because it's the only way a country can internationally commit to core provisions of data protection that are prescribed by the convention. And this is working quite well. So despite the fact that indeed it's a text that was elaborated in Europe by the Council of Europe nearly 40 years ago, the vision of its drafters, which was always a global vision of allowing flows of data between the parties to the convention, is becoming a reality since the year 2013, actually, with the first non-European accession to the convention. It was by Uruguay. And it's been followed since by a number of other Latin American and African countries. As you can see on the screen, today we have 55 countries that have committed to respect the provisions of the convention. So it's the 47 member states of the Council of Europe that I would, for instance, highlight Turkey and Russia, just to make the distinction also with the EU, for you to seize the spread, the geographic spread of the Council of Europe and its member states. And then, as non-European countries, you have them on the screen. You have Argentina, Cabo Verde, Mauritius, Mexico, Morocco, which is the latest comer to the convention, and we're very happy of that, Senegal, Tunisia, and Uruguay. So 55 parties. Burkina Faso was invited but has not yet completed the accession procedure. This is linked also to the legislative reform internal to Burkina Faso, which is underway. And what is also very important to note is that the committee allows participation of observers countries. And it's a way to really spread the good word, I would say, and involve countries, some that do not even have data protection laws, to the work of the committee. And the work of the committee is very rich because you have the convention that is the backbone, the key provisions, and then the committee will focus on a particular topic and describe how those key provisions apply to that topic. So, for instance, at the moment, the committee is working on facial recognition, on protection of children's data in the education system, on profiling. So we have a variety of topics we're dealing with. And indeed, it's a group of 70 countries that meet in Strasbourg twice a year to work on those common issues and adopt guidelines, adopt documents. 70 countries, so it's half of those countries that were with data protection laws, although there is no full coincidence. As I mentioned it, we have countries without data protection laws participating. So this forum, the convention, and the work that it carries on issues is of relevance for all regions of the world. That's why I think I've been invited to this panel, because accession by African countries, participation of African countries and Middle East in the work of the committee enables us to adopt common standards, and digital identity being one of the topics. This is the visual graphic of the spread of the convention, and what I'd like you to focus is actually on the white zones, which are also partly matching the white zones of the map of Professor Greenleaf, but not completely. And just to highlight that, bizarrely enough, the boom and explosion of ID digital national programs is indeed in the African and the Asian region. Is there a link, a correlation, a causality? I don't know, but it's just a fact. So another point I wanted to come on and clarify a matter about digital identity and legal identity is that we see a narrative which is very, very common lately, linked to the Sustainable Development Goals of the UN, and affirmation of the fact that the UN is pushing for digital identity for all by 2030. No, it's not what the Sustainable Development Goals foresee. The Development Goal 16 on peace, justice, and stronger institutions has specific targets, and one of the target 16.9, says that by 2030, the member states should provide legal identity for all, including birth registration. So we're not speaking about digital identity, we're speaking about legal identity. The problem indeed is that there is no agreed international definition of legal identity, and we all agree on the importance of securing identity for all. It empowers us, it enables us to exercise our rights. If we think about statelessness, people, they're subject to discrimination and abuse, and identity for all is certainly a goal that should be supported. But let's not say digital identity for all. There might be countries in which securing a legal identity may prove indeed difficult, and digital identity might be a solution, but not promote digital identity for all as the solution and the miracle of development for countries and whatever other objectives are mentioned. So we're focusing now on Africa and Middle East, but as I said before, we see an explosion of those national digital programs and the biometric technology that goes behind it, also in Asia. Here on the screen you have a screenshot of one of the latest programs implemented under the Train for Trade program, and you see the focus was on Indonesia, Philippines, and Singapore, some of them already developing their national digital identity programs. So the discussions we're having here today is actually not solely about Africa or Middle East, it's also about other regions. And if I can just also mention and bring it back to Europe and bring it back to my country, to France, not long ago, in 2012, the French Constitutional Court had to repeat that a national biometric database of the population is unconstitutional, because there was again yet decision on establishment of a biometric databases for the population. So the discussions are relevant to all of us. Precisely because it's relevant to all of us, and this sole international reference we have as a legally binding instrument being Convention 108 Plus now, which is the modernized form of the instrument. I want to highlight some of the provisions of the convention that are really key to this topic, and so I would consider would be the basis of the work of the committee on developing guidance on digital identity. What I would first like to highlight is that Article 3 of the Convention provides a fully horizontal application of the Convention, both to the public sector and to the private sector. And here, speaking about digital identity, whether we have in mind electoral databases, national registry, allowing social benefits managed by the state, indeed, the fact that it applies to public sector activities is a guarantee. The convention also applies to private sector, but so why would I mention private sector when we're actually now speaking about national registration systems? Well, we have seen that some of the firms deploying the technology have kept the national databases solely under their control, what is seen as the risk of vendor lock-in by some of those countries. So we could question the whole application of those provisions and safeguards, starting by the legal basis for the processing by those private firms in those cases. The Article 5 of the Modernized Convention is on the legitimacy of the processing. And there you see all the key provisions applicable to the data processing, a notion of proportionality, data minimization. All those are really crucial when you consider implementing such a databases. Article 6 is on sensitive data. That's obvious. It's the most relevant, one of the most relevant articles of the convention to this matter, because those digital identity programs nowadays are built on biometric data. And thankfully, with the evolution of the right to data protection, biometric data is now considered, both in Convention 108 Plus and in the GDPR, as sensitive data. I would just like to mention that under the explanatory report of the convention, we highlight that biometric data concerns both identification and authentication forms of recognition of the person, identification. Article 7 on data security is obviously very important. You can imagine the sensitivity of such national databases and the state-of-the-art technologies that should be implemented behind it. And finally, Article 10 of Convention 108 Plus, which foresees the accountability obligations as well as privacy by design, privacy by default, should be also considered in that context. So it should really be the basis.
One more minute.
And my last word is there is a lot of documentation on the topic, but I just wanted to highlight the recent work of the ICRC on the use of biometrics in the humanitarian field, which is also very important. And just to highlight that this topic, digital identity, is now agreed as one of the topics that the Committee of the Convention will be tackling from this year. And so we look forward to actively contributing with the African Network of DPAs and other countries on this topic to provide guidance. Thank you very much.
Thank you so much for being concise, covering a lot of ground. It's very, very interesting. And of course, you have a foundational importance across all the world, not just Africa, Middle East, as you said, also. But we switch now to the Middle East part of our presentation. And we switch to Tim Land, Director of Privacy Protection in the Abu Dhabi Global Market.
Thank you, Stewart.
You will explain what that means.
I will explain what that means. So in the Abu Dhabi Global Market is a financial and business district or territory created within the city of Abu Dhabi, which has adopted a common law legal platform and has a comprehensive data protection law applicable to any entities that process personal data within that jurisdiction. And so my office is the DPA responsible for administering that data protection law within that territory. And what I want to talk to you about today in the context of digital identity, and in particular in the Gulf states and the UAE, is the use of national digital identities to provide government services in a more efficient way. Because in the Gulf states of the Middle East, it's the push for national digital identity is all around the improvement of government services. So a quick...
The slides are not here.
Here we go. Quick overview of the Gulf before I then zero in on the UAE. And I'll explain why I'm going to zero in on the UAE in a moment. And it's not just because I live there. most, if not all, Gulf states in the Middle East have implemented or adopted a national digital identity scheme in one shape or form or another. But as I said, the adoption of these national digital identities is in relation to the delivery of government services or e-government services. And this has been a sort of a natural progression from where all different government departments in these jurisdictions set up their websites and provided online access to their services. The next natural progression was, okay, well, why don't we have a single sign-on to make it really easy for residents and citizens and visitors to just be able to access any government service they need with a single sign-on instead of having to have separate logins for every different government department they deal with, whether it's the lands registry or the Department of Traffic and Roads and so on, Department of Health. And so it's not about any national registry of births, deaths or marriages. It's not mandatory. It's purely in relation to the improvement in government service delivery. Okay, so I'm not trying to give you a geography class in the middle of a data protection and digital identity session, but just this will help you the next time you're having a quiz night and anyone asks, what is the capital of the UAE? It's not Dubai, it's actually Abu Dhabi. And just to put it in context for you, before I go into how digital identity schemes are working in the UAE, is to just explain the fact that the UAE is a constitutional monarchy that's made up of 7 states, or emirates, as they're called there. And although Dubai is probably the most well-known and the largest city within the UAE, Abu Dhabi is the capital. And if you can see the little blue star, that is where the city of Abu Dhabi is, in Abu Dhabi, in the Emirate of Abu Dhabi. And the population is around 9 million people, and around 1 million are Emiratis, or nationals. So why am I focusing on UAE? Well, out of all the Gulf states, arguably the UAE is probably the most active when it comes to digital transformation. That is actually being led by the government, the public sector, not the private sector. The government has really latched onto and wants to really transform itself. It's even described it as disrupting its own government in the provision and delivery of services. The UAE government has adopted an AI strategy. It's the first country in the world that's actually appointed a minister of state responsible for AI. His name is Mr. Omar Al-Alama, and he's a 29-year-old who is driving forward their AI strategy. There's a blockchain strategy. The government has also announced that it wants to be completely paperless in terms of providing transactions to residents and citizens by 2021. And if you've ever been to the UAE, you'll know that there's not many trees, so that's going to be a really good thing for the environment to go paperless. Okay, sorry, that was a bad joke. So really, the reason why I'm focusing on UAE is that they're really focused on digital transformation. So where does the National Digital Identity Scheme fit in? Or what are the drivers, sorry? They want to do this to stimulate economic growth. Over the last few decades, the UAE's economy has been predominantly focused on or dependent on oil and gas. The government recognises the need to diversify their economy, and they want to introduce a knowledge-based economy into the UAE. And so strategies like adopting AI and building out the tech sector, creating an entrepreneurial tech-focused sector in the UAE, they're hoping will help stimulate economic growth and diversify the economy. It will help save costs in the delivery of government services. If you enhance the way that e-government services are provided, that can reduce costs, increases speed and convenience for residents and citizens as well, and just generally enhance government efficiency. So the UAE's National Digital Identity Scheme fits into that whole digital transformation piece that the UAE government is pushing for, because it's one of the key pillars in terms of providing a single sign-on or that single channel for citizens and residents to obtain government services. Like I said before, whether it's registering your car, renewing the registration, registering your tenancy contract, getting health services, and so on, it is the key, but it's not mandatory. So you're not locked out from getting government services if you haven't signed up to the scheme, importantly. And as you can see there, out of a population of 9 million, only 165,000 people have signed up so far. But it's still relatively new, and I'm sure the government are hoping that as awareness of this becomes greater, the adoption will increase quickly. So,
2 minutes.
Sure, thank you. So there's lots of benefits proposed in terms of saving costs, improving ease and efficiency and speed of gaining government services. But what are the risks, and where does data protection and privacy fit into this? Well, at the moment in the UAE, there is no federal comprehensive horizontal data protection law. There's a lot of work going on within the government to prepare one, and it's possible that a federal comprehensive law may be introduced this year in 2020. We hope it is, and my office is consulting with different government stakeholders in that regard. But at the moment, what we have is sort of a patchwork of different privacy provisions across a number of different statutes in UAE laws, both at an emirate level and at a federal level. And so there's articles in the penal code, there's privacy provisions in the telecommunications law, in the cybersecurity laws, and interestingly, last year, Federal Law Number 2 of 2019 introduced a lot of what we would recognize as key data protection principles or concepts into the way that medical records and health data is handled by medical institutions in the UAE. So that's an example of where they went down the path of a sectorial approach, but now I think they recognize the need to have a federal comprehensive law, and so they're working on that. Within my jurisdiction in Abu Dhabi, as I said, we have a comprehensive law, but it only applies in our jurisdiction. And so I guess the note I want to finish on is that the government is pushing ahead with digital national identity. It's not mandatory, but the driver for it is really to improve the delivery of government services and decrease the costs. And now data protection and privacy needs to catch up. I don't think in any jurisdiction data protection will ever keep up with technology, but at least we need to try. So I'll leave it there. Thank you.
Thank you. Thank you, Tim, for keeping exactly to time. And it shows the point that the drivers for data protection law is not always human rights driven as we are in Europe, and we like to think so, but e-government and other developments of the e-economy are drivers not only in your area, but also in Singapore, Korea, and other jurisdictions. Right, we hand over immediately to Ghana, to Patricia Poku, and you're head of the Data Protection Authority in Ghana, and also Vice President of the African Network of Data Protection Authorities.
Thank you. So my focus here is to look at the landscape of digital ID in Africa. You notice from Sophie's map, the blue map, that a lot of activities around the western part of Africa, where many members of the ECOWAS area have passed the law, is because following discussions at the AU level, there's also the ECOWAS Supplementary Act that has mandated most West African countries to have enact data protection laws. So across West Africa, most countries have their Africa data protection laws. And I don't know if the slides are there, but I didn't intend to use them. Okay.
Have you got,
no.
Do you have her slides from Ghana?
No, don't worry.
Sorry.
Just listen attentively then. Okay, so across West Africa, we're quite, almost every country have a data protection law. However, we have it dotted around the rest of the African sub-regions. So we in Africa, in the ECOWAS West, in East Africa, we know Kenya has just passed a data protection law and is working on their digital identification for their nation. We have in South Africa, we have Ethiopia working actively to pass their law. Countries like Uganda has also got theirs and working with it. and in the northern part of Africa, we see Morocco and other countries taking the lead in data protection. And this has been a basis for most of the countries also to look at how to improve inclusivity in mainly in our financial sectors, where our drive is for having beyond a legal ID some sort of digitally enabled identity that would help the more rural areas of Africa be included in mainly business activities. So the drive in Africa is not so much focused on human rights, or as in the UAE, a government-led need to use digital ID. It's more on enabling financial inclusion, or to enable a better reach into our rural users, and more enable communities without enough access to the center to be able to be included in business and in the economic activities. That has been a major drive for most of Africa, in the need to have some sort of digitized ID alongside the increased use of technology. We find that typically in Africa, this has been led by the financial sector, and enabling financial activity has been the main drive for the use of digital ID. So far, it's been good. Those who are enabling digital ID are increasingly moving towards having a nationwide use of a digital ID system. However, there are some challenges in the region, the African region, in how this has gone about, and the enabling human rights alongside the use of digital ID is the area where we've had problems and challenges. As data protection regulators, our focus obviously is on enabling privacy as a fundamental human right in the region. And so aligning this mandate with the pace of use of technology and enabling the respect of human rights, or enabling individuals to be able to exercise the rights that they have been given under data protection laws, is where we have our most challenges. We also obviously want to keep up with international best practice standards that has been set, usually mainly by the Council of Europe, who through the activity mostly led by our dear Sophie Kwasny here, has brought a lot of African countries to the fore to discuss how we meet the international best practice standards of how to, one, operate a supervisory authority, and to support the people to understand their rights and to enable the exercise of these rights, whilst holding institutions that lead the use of, if we are focusing on this discussion, the use of digital ID systems, how to enable proper accountability, and to kind of educate them to want to do it. It's not the punitive measures that is helping us, because it's very hard to, as a regulator in Africa, push for the enforcement of laws to the extent of applying the relevant penalties, but it's more of a focus of enabling institutions understand the implications of this digitized environment and the use of digital IT on individuals, so much to want to do the right thing by wanting to enable the accountability principles that has been promoted on the global landscape, such as data minimization, such as enabling participation and transparency with the data subjects. So some of the specific challenges we've had is the size of the data sets that is being collected as part of digital ID system implementation. In Ghana particularly, we have a very wide set of attributes being collected in the name of digital ID. You find that it's gone beyond the basic need to know to have a database to the collection of biometrics beyond fingerprint. Some areas are looking at digitized collection around iris scanning and the use of other forms of biometric collection. That doesn't marry with the rest of the ECOWAS area when you look at the purpose for which we are globally looking to have a digitized identity. This morning as we were chatting, we were looking at whether we really need to look for a legal ID that is not necessarily digitized, or whether the digitized ID is what we really need at this time in our lives in Africa, considering the level of awareness and knowledge of how to actually use this, the application of other areas of AI when individuals can be uniquely identified using digitized ID, to such as using that in profiling and deep machine learning, is some of the issues that we are currently grappling with. We've looked at other countries, such as in Kenya, where there's a need to raise awareness and to educate the public and the communities that are supposedly being going to be empowered to be included in the digital economy, and educating them as to what the actual purpose of the collection of data is and what needs to be collected in order to digitally identify an individual. We heard of a story recently where in Kenya they have decided to use a blood group as one of the attributes in the identification of people, and communities have been misled and have misinterpreted the purpose for which this is being collected. And so soon as the collection team reaches the community, there's a mad rush of people running away because they're thinking that the blood being collected is going to be used for all sorts of occultic reasons by the government. And so that a mix of cultural fear and superstition has been mixed into a project that is potentially going to enable some increased inclusiveness in the communities and to support them, because of the lack of consultation of the public has been misunderstood. This is a typical problem that we have, where consultations haven't been done to the extent where the beneficiary of the exercise would be able to understand and be empowered to also participate in the exercise, and also feel that they have understood it enough. When you think in terms of consent, how consent is supposed to be collected before a project of this nature is deemed successful, it hasn't been applied properly, where individuals and communities have not been properly educated or made aware or been involved in the project at the stage, the conceptual stage, where there'll be proper buy-in to enable the collection in a way that will involve the key people and to enable a full onboarding of everyone who's entitled to have a digital ID. Gosh. So we've had those sort of challenges in Africa in the use of digital ID. Also, we in the supervisory authorities haven't felt like there's been a proper stakeholder analysis that tells us that the right institutions will have access to the digital system once it's been put together, enough so that we know that the right third-party sharing will happen following the collection of the data. So there's a worry about who is going to have access to the data and how this will ensure that data is in the right hands. That is a challenge that we have in Ghana. The collection of data in Ghana is far advanced now. The launch of our digital ID system started in September 2015. Since then, about 7 million members of the public have their digital ID. I have mine in the bag. But there needs to be about 14 to about 12 million adults need to have digital ID. And the target is to have 10 million before the system is put into general operation. In the meantime, we have private entities that are popping up and offering the business of identity management to, say, the financial sector. And so that is hard to control, and that is leading to sale of personal data in various forms from government and from third-party areas. And I'll cut it short because I'll exceed my time. Thank you.
Thank you so much. Thank you so much. That's extremely interesting, talking how the programs are rolling out in different African countries. You talked about cultural awareness. You talked about the difficulty of applying fundamental principles to the various schemes, and some involving blood and solving national systems. And interestingly, that in your country, the target is 10 million people to be added to the system before it goes live. Turning immediately to Dr. Oliver Butler, Wadham College, Oxford. Please go ahead. And we need to move on this.
All right,
Can you have the slides, please? Great. Right.
Thank you. So thank you for asking me to speak here today. I'm going to talk a little bit about the impact of GDPR beyond the EU with a focus on Mauritius as a case study. I think the reason why it's important to do that is it's very difficult to generalize about regions so large and diverse as Africa and the Middle East. But there are some valuable points that you can draw out of Mauritius as a case study, a country that's recently strengthened its data protection provisions in response to the perceived benefits of harmonisation with the EU. And I want to draw out some of the concerns that come out of that process. So my topic today relates to broad political factors that may shape the development of national data protection laws in Africa or the Middle East, and thereby the development of digital identity systems in those regions. I think it's important, though, to highlight the ways in which it's not just the substantive principles that are important, but also the way in which those are enforced and implemented in particular jurisdictions. And sometimes I think there's a disconnect between a focus on the substantive principles for data protection and the impact that those enforcement regimes have. So I'm going to seek to draw that out. In particular, I'll focus on the EU adequacy decision procedure, which will be familiar to most of you, and the pressure it may come to exert on countries outside the EU. So sometimes this is described as a feature of the European Union's soft economic power exerting a pull towards upward convergence in fundamental rights protection, in this case, data protection. As you'll well know, EU adequacy requires essential equivalence with the GDPR in seeking an adequate level of data protection. Now that's important where countries are consciously seeking adequacy decisions, as is the case in Mauritius, but I think it's also of broader importance because the design and implementation of digital identity systems may have implications for future attempts to seek adequacy. And that's especially in the case of digital identity systems that rely on the extensive use of biometric data. So we spoke a little bit about the way in which your development of a system may result in lock-in to a particular way of doing things. And one aspect of that perhaps is also the way in which it might therefore lock a national data protection system out of higher standards over time. So first to talk about the EU adequacy framework and the way in which that's had an impact on Mauritius. Well, I think the first thing to highlight is the way in which the influence of adequacy decisions is highly variable. Adequacy isn't the only way of data flows between the EU and third countries. And in the absence of a data protection adequacy decision, beyond limited derogations, there are also those means of setting up appropriate safeguards with enforceable data subject rights and effective legal remedies, such that the adequacy decision is not the only way to do those transfers. So, because data transfers are possible under the GDPR without an adequacy decision, The key impact that you find is the removal of those additional burdens which inevitably increase the costs of arranging transfers, and especially new transfers. But that not being sort of universal in its pressure and its application. So in Mauritius, that's proved an attractive proposition, and the rapid adoption of the Data Protection Act in 2017 reflected that. A number of other countries, both in Africa and beyond, Graham Greenleaf's work in privacy laws and business has been good at mapping this, show the impact of that desire for adequacy beyond the EU. But it became difficult to assess how strong that pull is or will be across Africa and the Middle East, where there's a range of exposure to different European markets, and different industries have different perspectives on the value of adequacy. Mauritius being a good example of this. So it's the IT outsourcing sector in Mauritius that has pushed for attempts for adequacy. And you tend to find more in the finance industry in Mauritius that pressure isn't felt so keenly. It's got established relationships with its European markets. It's already done the work necessary to establish adequate safeguards. This may also change based on the perspective of potential competitor markets. So one interesting thing that comes out of the Mauritian discussions is the way in which the long-term strategy of India might impact upon their outsourcing industry and fears that have been expressed there. In relation to digital identity systems, one possible area where this might exert a particular pressure is in relation to biometric data processing. So one of the important trends, I think, in the European Union is an increasingly critical approach to facial recognition, alongside the now existence of biometric data alongside other special categories, and therefore requiring either express consent or, in the case of public sector data processing, more likely to be particular legislation setting out the substantial public interest in that processing. And that's alongside, of course, a lot of other potentially demanding data protection principles, so accuracy, fairness, data minimization, and data retention all fall into those categories. A concern then that arises in relation to the implementation of data protection legislation in countries outside the EU is the relationship between mirroring substantive principles and its national enforcement. And I think we see that in relation to the Mauritian Data Protection Act and its intense focus on criminalisation as the key enforcement mechanism. So there are, of course, various offences in relation to breaches of data protection law, both in that legislation and found more generally in data protection laws. But what's interesting about the Data Protection Act in Mauritius is its catch-all criminalisation provision in Section 43, which anything that otherwise contravenes the Act becomes a criminal offence. That's found in relation to a number of other jurisdictions. So I've identified similar provisions in national legislation in Algeria, Egypt, Kenya, Togo, and Botswana. It's found not just in Africa and the Middle East, but also beyond as well. Now, why might that focus on criminalisation as an enforcement mechanism present particular problems? So, of course, there are unforeseen civil liberties concerns associated in that form of enforcement for data protection. I think it would be a huge source of concern to European companies if they were told that their non-compliance with core data protection principles was a potentially criminal offence. And of course, it depends very much how that's used in a particular jurisdiction as to how large those civil liberties concerns become. But it does have important aspects beyond that general concern for liberty in the implementation and interpretation of the national principles. So where you have broad criminalisation, that I think can threaten the success of national data protection and through it identity systems. And there are three reasons I think why that's the case. The first is that it can lead to a restrictive interpretation of the national legislation. There's no guarantee that using the same wording in the Mauritian Act as in the GDPR would result in the same application of those principles. Rather than the broad purposive interpretation that's typical in Europe, you'd expect there to be some narrowing of the interpretation to reflect the fact that where a principle's application is ambiguous, that can have a detrimental effect on the defence. That also has an impact on implementation. So where there's ambiguity about the proper application of the law, you might expect those implementing digital identity systems to take a cautious approach, fearful of violating a national criminal provision. And thirdly, it can also have an inhibiting effect on data protection authorities. So one challenge found in Mauritius has been the reluctance to use its criminal powers in order to enforce, based on the feeling that that's heavy-handed or disproportionate response to breaches, especially breaches where the interpretation of the law may be unclear. So in all those three ways, it can inhibit the successful implementation of digital identity systems. My conclusion then is to sound a more cautious note about enforcement through criminal provisions. Given the legal uncertainty that's inherent in a lot of data protection principles, and really to highlight the value in the development of national data protection laws of proportionate regulatory enforcement or administrative fine systems, which might be a better way to promote effective data protection while avoiding some of the potential negative effects of criminalisation as an enforcement mechanism. Thank you.
Thank you very much indeed. And we have to move on immediately to Omar Seghrouchni, President of Morocco's Data Protection Authority and leader of the Working Group on Digital Identity in the African Network of Data Protection Authorities.
Thank you, Mr. Dresner. I want, first of all, to thank the organizers about allowing me to contribute to attend to this panel, and also thanks Mr. Dresner and Mr. Anis for this. My presentation is about identity, and you read on the title that we speak about we are between best practices and bad ideologies. Bad is between code marcation. Perhaps they are good. It's only to provoke the debate. Oh. Mrs. Kwasny talked about the relation between the legal and digital ID. I want to focus on the relation between digital ID and the unique ID. We can have several academic definitions, but let us, for our panel, to be simple and practical. Identity, in my family, is my first name, because my brother has the same name, the same last name, and to distinguish between us, we use our first name. In my district is probably my first name, my last name, and my address. My school is all this, and we have also the date of birth, the place of birth. In my country, we add the national identity number. In the world, we add the nationality because with my passport, which is a national document, I have the other documents. But there is also some little thing which is with this identity. Is my criminal report. Don't worry, it is empty. But in our reflection, the identity now in a lot of countries in the Middle East and North Africa, but also in the other countries in the world, we have a lot of projects to computerize identity And I say here it is identity in the IT world, and it is different from the digital identity. I will try to explain. Usually, it is done for more efficiency. So, the efficiency is proposed as the best value we can have by this operation. What about my criminal report? This criminal report, in fact, is extended because in the criminal report there is only the potential condemnation and the judgment. Today, we have in this new world, the digital world, all events I can do, I can life, the bad and the good. We have an extension of the concept of criminal report with the life report, and more than that, an intimate life report. So, when we talk about digital world, we talk about these things: identity in IT world, the intimate life report, and also a new mode of governance based on human decision, AI decision, and algorithm decision. So, working with a digital ID is today, it is not a simple computerization for efficiency, it is the implementation of a new model of governance. And the problem, it is not on the blue line, but it is on the green one. Digital identity is not just a computerization of the concept of identity. It is more than that, and I just say it, it is a deployment of a new mode of governance. It is not only a question of efficiency, of social and economic concern. What do we want to target as a model of society, as a governance, and as a human rights, and as a democracy? Do we want a ranking society? Because the question is this: without protection rules, the ranking society and the unique ID base, which is the base of, there is a mistake, social credit, is perhaps acceptable in unique party systems. But what about multi-partyism and democratic system? We hope to live in digital open societies and not in digital closed societies. The unique ID is a concept which is just a technical way to implement the digital ID. It is not the only one, and we should study this. So, we are not against the aims we want to reach. We want to discuss about the way we will reach these aims. We could implement digital ID by using other techniques based, for example, on decentralized and sectorial IDs. We should study the decentralized architecture. We should work together not only in the Middle East and Africa, but also in Europe, America, Asia, and worldwide to ensure that the new mode of governance, we can name it data governance or digital governance, will be deployed with a respecting human rights and democracy paradigm. Digital ID, another time, the unique ID is one way. There is other ways, sectorial. I should accelerate. Yeah.
2 minutes.
Hein?
2 minutes, s'il vous plaît.
2 minutes, d'accord, très bien. Very quickly, it's a map which is not completely updated. It's only to say what Mrs. Kwasny told before. It seems that unique ID is stronger in the countries where the DP law or DPA is weaker or not existent. Very quickly, if you see the green curve, if you see this curve through the window number 1, the optimum is the point A. But if you see the same curve through the window number 2, the optimum is the point B. And the same curve through the window 3, the optimum is the point C. Today, we are seeing the problematic of identification about several projects and efficiency of these projects. So we see them only by through a local optimum and not always a global optimum. Thinking efficiency is local thinking. Thinking efficiency concerning democracy is a global thinking, and we should have it. Perhaps there is a lot of things there, because perhaps I finish with this. Sorry. The European Union seems to announce a moratorium on facial recognition. In Morocco, we have announced it in September, the last September. We should perhaps deploy digital ID, of course, but digital ID does not mean unique ID. Should we think for a kind of moratorium on unique ID to study and ensure altogether a decentralized and sectoral approaches and the separation, and it is very important, between usage data, the intimate life report, and identity data. The last words are, I think that I have green, yeah, because green is the bad curve for me. In Pantagruel, Rabelais, the French author, said, "Science sans conscience n'est que ruine de l'âme. Science without conscience is only ruin of the soul." We can say efficiency without democracy is only ruin of human rights. Digital without personal data protection is only ruin of the soul.
Thank you very much, Monsieur Seghrouchni. And I'll remember here the great words of Giovanni Buttarelli, who was here last year, unfortunately, no longer with us, who said, just because you, head of the EDPS, who said, just because you can do something does not mean that you should, which is a similar kind of sentiment. You said, now, we're virtually out of time, but if anyone has a particular question or comment, then please come to the microphone très vite. And so just 2 people want to say something, so let's go quickly, please.
Thank you, very interesting. Can you tell a little bit about what these digital IDs you've been talking about look like, very briefly? Are they username, password? Are they card-based? Are they in the form of apps, which are now on phones? Can you give us some sort of an impression of what's going on?
Okay, thanks. We'll take that question first. So we got an example. Can we have for each country, like in Ghana?
To show them
Oh yeah, we're going to have a demonstration, a live demonstration of digital ID. Fantastic. We have talked about, Tim, you talked about in your area, used for driver's licenses, I think. So, yeah, so this is a biometric ID. We can hold it up, yes. So it's a card with a little, what's that called?
Chip. There's a chip with a lot of information on. It's also going to be an ECOWAS passport.
ECOWAS
enable people to travel seamlessly within the ECOWAS community.
Which is West African.
West Africa, eventually.
Is there biometric data?
A lot of biometric, everything, my eyes, my fingerprint. is in there,
There's a photo,
and my photo is in
very
there.
attractive photo. And there's an iris scan in there somewhere.
Yes, and we've been informed that it's one of the strongest security in the world,
We have.
apparently.
Okay, thank you. And some examples that
Yeah.
your area.
So Stewart, in the UAE, as a resident, I have a resident identity card, and citizens have the same as well, the Emirati nationals. And to sign up to the national digital identity scheme, the UAE Pass, there's an app, and you just scan the card onto the app, put in a PIN code that you get sent, and an extra validation via an email address. So there's 3 layers of validation to register, and then the final step to fully unlock all the features of the scheme is that you do have to go to a government office where you would then have your fingerprint scanned for that biometric verification as the final check.
Right, thank you. And Mr. Seghrouchni, I think you said that in Morocco, this is part of the health plan. I think, did you say that? Or somebody told me that in Morocco, digital identity is used for accessing health, or is the plan to do that?
No, there is a plan for a social project to decide which people is eligible.
Eligibility for health
For
care.
this, and we have a discussion. It is not yet decided because we hope that we can convince people that the sectorial ID is better than the unique ID, but we are not sure.
Yes, that's okay. And is it used anywhere for transport, for buses or trains?
This will practically be used for everything. It's got your health card, your driving license details, your pension, your life, basically, almost everything that was separate, other identities, your passport details, your location, your home address, your telephone details, even your next of kin is on here. Everything.
So, do you want to say something, Sophie? Final comment?
I'd rather have another question.
Yeah, sure. So it's either a nightmare or a wonderful future, whichever way you like to look at it. Okay, please.
Exactly.
So thank you, merci, and shukran.
Give everyone your name, please.
Pat Walsh, Privacy Matters.
Yes,
So it's interesting, thank you for all those discussions. So there's something that each of the countries that are represented here, except for the UK, of course, so Ghana, Burkina Faso, UAE, Morocco, there's something you already have in common, which is a digital identity in the form of mandatory mobile phone SIM card registration. I'm even at Ghana's database, for example, after visiting last year. Yes. So you have this digital identity that exists already, and to take the point in the UAE, it's not mandatory. However, where we see communities that live in rural areas without access to a physical infrastructure, to an office where they can go, of course they're going to use digital services.
So you have a particular point?
I do, which is, shouldn't we be looking at human rights impact assessments here? Because this is much bigger. In the form of mandatory SIM registration, it's mandatory, which is increasingly becoming biometric, particularly in Africa and the Middle East. This impacts on your multiple fundamental human rights. Right to be free from arrest, for example, right to freedom of movement, right to freedom of association, right to freedom of expression. We see these being infringed regularly. So shouldn't we be looking at human rights impact assessments?
So your point is there is a risk of mandatory use of biometric identification, which is a challenge to one's human rights?
I can tell you right now that this is being abused in Nigeria, where people are stealing people's identities in order to access their national identities.
Right, so that's a risk. And now we're going to have a response from Ghana.
So, yes, you've hit the nail on the head. When I started speaking, I was speaking at the drive for this, not focused on human rights as it should from regulators or regulator of a data protection perspective, but there's more focus on the benefits to be gained, financial inclusion being one of them, unique identification and access to services being the priority focus, whereas it should, because of the implications and the volume of and the sensitivity of data being collected on this card should be closely aligned with human rights, and that's what we are pushing for. And this morning I was actually discussing it with a group of how we are going to enable privacy as a fundamental human right on the agenda of the African Human Rights Commission in order for the government in Africa to take it that serious.
Yes, and you said that privacy should be added to the list of objectives of
That's
the
right.
Union of African Union, African Union, I can't remember what it's called now. Union of African States or something.
Yes. African Union and the Commission of Human Rights itself should highlight privacy as a fundamental human right in order to push for states in Africa to see privacy as what it should be, a fundamental human right, which should be considered in projects of this nature. Okay. But it's currently lacking.
Okay, any 10 seconds each to finalise. Each of you, Marguerite, do you want to add something? Or anyone? So you've got 10 seconds, final comment if you wish.
Relativement à l'identifiant unique, notre souci en tant qu'autorité de protection, c'est que les principes fondamentaux, et notamment les droits des personnes, soient respectés. Merci.
Okay, merci. Okay, Tim, final comment?
Thanks, Stewart. Thank you, everyone. And I think I haven't touched on it, but data breaches, I think, will be probably the biggest concern going forward that we have with national identity schemes or digital identities in general, whether it's public or private.
Yes, so first to say thank you for this excellent panel. One thing that I think comes out, especially in the questions, is that these systems don't just implicate privacy, but a whole range of rights. And so one thing to think about is how to tie all those things together.
Good.
My few words is that the data protection is a building with several levels. And the ground level is what we discuss usually. The first level is what Mr. Considered about the SIM, for example, the SIM number, is the building of the 360 vision. And the question is, what is the larger of this vision? And it is very problematic.
Okay, thank you. And Sophie?
Yes, only to highlight indeed that there is the broader picture. We have focused on those national biometric ideas and digital ideas, but indeed you have in the banking sector, in the telecom sector, also interest in the development of digital identity, so we should see it also more broadly.
Yes, thank you. And my final word is that this question of the tension between biometric identification, digital identity, and privacy applies to all countries. It's not just Africa, not just Middle East, also Asia and in Europe. And thank you, Sophie, for reminding us of the Constitutional Court in France, which banned the use of a biometric database in France, which is the upholder of fraternity, liberté, and égalité, as we know. Thank you for the French Revolution, which brought these concepts in. And finally, I have to mention that Professor Graham Greenleaf, who produces all this wonderful data, has been our privacy laws and business Asia-Pacific editor for 30 years, and he gives his exclusive first release of his information in our publication. He writes for us and have a whole network correspondence all around the region. So, and we have information if you want about our publications. Please come and pick one up. And I'd like to thank all the panel. We've had started 5 minutes late, we're finishing 5 minutes late, so we got our full time. Thank you very much.